we don't know for sure, but it is probably not, a court will probably conclude that criminal charges cannot be brought against a sitting president. The most important Supreme Court precedent is United States v. Nixon, which was decided in 1974. The Supreme Court held that President Nixon wasn't entitled to an executive presidential privilege from turning over tapes regarding Watergate that had been requested, but it did not decide the question of whether or not the president could formally be indicted. But certainly from an institutional perspective, it would seem damaging and potentially damaging in an irreversible way for us to have come to a place where the 45th President of the United States is criminally prosecuted while in office. So I think that the better course, and most constitutional lawyers would say, let's not go there. Ultimately, maybe the better course here is to impeach and then pursue a criminal proceeding after the fact. In our Constitution, impeachment is entrusted to Congress. It is not a legal proceeding. It takes words that sound legal, like the term of art, high crimes and misdemeanors, but ultimately it's Congress that gets to decide to indict and to ultimately convict on impeachment. The remarks he made to FBI Director Comey, one logically thinks of obstruction of justice. And the statutory crime has three sort of elements. One is there has to be something criminal going on, a proceeding that you're obstructing. That's probably met in the case of the investigation into Flynn, even though it was preliminary. Second is you have to have an obstructing act, and it seems to me if the president did in fact communicate, I don't know what the exact words were, but I hope that you will let this go, or whatever, it seems to me that that can objectively be construed as trying to interfere with the proceeding. The trickiest is intent, and lawyers call that the mens rea requirement. When he did these things, assuming that it gets proved, and the FBI director apparently kept a memo after the fact where he recorded his observations, and the question of intent boils down to when the president did this. Did he know that he was doing something wrong? And did he do it anyways? And that's tricky, because in some sense you're asking yourself to read somebody's mind, but there's some objective indicia indicating that might in fact have been his state of mind. I mean, he told other people to leave the room. Why do you want privacy? He certainly made public remarks indicating that he thought the investigation about Russian influence was unfounded, and that's sort of circumstantial ambient evidence. So I think that even if we were to say that high crimes and misdemeanors requires a statutory crime in the crime of obstruction of justice, I think in this particular instance, there's actually enough there to say it's plausible.